Hi, my name is Olajide Olagunju, and I'm the author of How to Resolve a Conflict, which is the book um, right in front of you. Um, this book guides the lecture series which you have just joined, and the lecture series is titled How to Resolve a Conflict. This is lecture 26 in this series. Once again, welcome, and then I hope you uh, benefit from this to this edition of How to Resolve a Conflict. Thank you for coming. Um, as I said, the textbook that guides our discussion is the book I just showed you, How to Resolve a Conflict. And yesterday, we were looking at forms of agreement. That is after the mediation or at the end of the mediation, what the parties sign as their new perspective, the way they want to have to relate going forward. We said the agreement could be in the form of a simple agreement. It could be a deed, it could be a consent judgment, and it could be a consent award. And it could be both a consent judgment, and a consent award. So let's go on with the help of the book to continue our discussion. Um, I read, a simple agreement is usually um, sufficient in mediation because of the level of trust that the process would have generated, which would diminish the likelihood of violation of the agreement. A simple agreement is adequate for small disputes. Where parties, and this is where we're going today, where parties are either a government or a company, the implementation of the settlement or the agreement may run into um, itches when officials who did not take part in the mediation are subsequently required to implement its agreed outcome. These officials, for one reason or another, may be reluctant to execute the settlement agreement. It is for this reason, in my opinion, that parties sometimes choose to express the mediated agreement in the form of a deed to ensure that the agreement is enforced. It is also for this reason that parties sometimes agree to apply for a judgment on the terms of settlement, which is what I call consent judgment, with the effect of transforming the agreement into a judgment of the court and enforceable as such, and or that the mediator now acts as an arbitrator for the sole purpose of giving an arbitral award embodying the terms of settlement. That is what we call consent award. Now, I already explained this yesterday. Uh, I mean, the implication, the meaning of a consent judgment, a consent award. But what I need to emphasize now is the what I just read from my book. The fact that sometimes the in especially in mediations involving uh, governments and corporations, it's true. I mean, those of us who are lawyers, and in fact, uh, many other people know that in law, a company, a what is called a limited liability company or an incorporated company, is deemed to be a person by itself, and that gives us the power to enter into these kinds of agreement and all kinds of agreement, or many kinds of agreement. So it could be a corporation, it could be a government. But we also know that the corporation, the government is made up of human beings, people. And so if today we reach an agreement, a mediated agreement, and amicable settlement, it is those incumbents, the human beings who are running their corporation or government today, that sign in effect. But they are signing as a company, as a government. And technically and ideally, the agreement binds them. Now, if you just leave that, they just sign like a simple agreement and go. Tomorrow, when there are new sets of human beings, officials of these corporations and governments, they may elect not to implement what you agreed, what the company or government agreed today or previously. So what do you do? Now, the big, of course, grant for them to disagree if they want to probably be mischievous or not want to do their duties, because the fact that they are the officers there now does not mean what their predecessors signed is not binding. It's binding. It's an act. What they did yesterday, previously, was the act of these governments and corporations, which are recognized in law as persons, legal persons. So as I was explaining, that their ground for not wanting to, the only ground probably that they could put forward or one big reason is, well, there's no consideration where the government or the corporation was led to enter this agreement without getting anything for it. There's nothing that's coming for the government, that the government is benefiting from signing this agreement, so we will not implement. So what do you do? What does the other party do? They may be able to make the government go to court, make the government do what it's supposed to do. Particularly, as I said, if you are in the civil law countries, like France, they may be able to get a judgment, but again, that could result to a waste of time and all of that. So the way to deal with that is to make sure the agreement is a deed, expressing the agreement that this is a deed. The seal, the common seal of this government is attached to this agreement. It becomes a deed. If you were not corporations, you would say if it's an ordinary person, not a corporation, government, of course, you would have said. And sometimes you need to do that because, again, the agreement may be enforceable against the heirs or the successors in title of the original person. So even for in situations, in mediation between individuals, human beings, real human beings, it may be nice to also express in the agreement it is a deed, and that is for ordinary human beings. It is what you write is, at least in English, it will be the seal. The parties have affixed their seal to the agreement. The expression uses signed, sealed, and delivered by the name of the person signing, entering into the mediated agreement or the agreement. So back to especially corporation and governments, their officers being reluctant to implement agreements reached. If you express in the form of a deed, an agreement, if you make the agreement a deed, of course, they cannot say there's no consideration, because once it's under a deed, they are bound, even if there's no consideration. That is the law. Also, if it's a judgment, of course, it becomes binding. If it's an award, it's binding, whether or not there is consideration. I think that should be sufficient for now, in terms of the binding nature otherwise of the agreement reached. And maybe I just read some more and then we can continue. While a consent judgment might be more appropriate for a local mediation, that is one within the same judicial jurisdiction, consent awards are more suited to international or inter-jurisdictional mediation. That means where the parties come from different jurisdictions. A court will always agree to enforce what is presented as its own judgment, even though it was given as a consent judgment. So when you come to that court, you are saying implement what you entered as your judgment, previously. A judgment from a different jurisdiction might be more difficult to enforce. So if it's not a judgment of that court, you are bringing from another jurisdiction. Well, the court that you are asking to implement may be reluctant to implement it. Now, commercial awards are more easily enforced internationally by virtue of the UNCITRAL Accord, which requires that the countries signatory to the accord enforce awards given in other signatory countries. So the challenge with enforcing a judgment in a jurisdiction different from the jurisdiction from where the agreement came or the judgment came is solved by this international accord, the UNCITRAL Accord. And so when you arrive at an UNCITRAL jurisdiction, that's all the jurisdictions that are party to the UNCITRAL Accord, then you don't have to worry about enforceability across jurisdictions, because all the countries have agreed that if an award comes from any country signatory to this accord, it will be enforced in each of our signatory countries. So that's why it may be ideal not just to get a consent judgment for the mediated agreement, but to also get an award for it, a consent award for it. Of course, it would be ideal to state in the award that it is given pursuant to the UNCITRAL Accord. Now, the UNCITRAL Accord has been domesticated by the country signatory to them. So, well, let me say it's most likely has been domesticated. That means that also become a law of the country. For example, in Nigeria, the UNCITRAL rules, so the UNCITRAL Accord is domesticated as Arbitration and Conciliation Act. And it was passed in 1988. It's still part of the law. And so what I'm saying here is that it might be ideal to state that the award is being given under the, if it was, the agreement was the jurisdiction where the mediation was carried out and the agreement was reached. If technically it's Nigeria, you could say the are called, the agreement is the award is given under the Arbitration and Conciliation Act of Nigeria, 1988. I think that's pretty clear. It's just very important for us to understand this little housekeeping, which may become important in future, and what mediation tries to do, or does, really, is to avoid confusion. We want to make everything clear. Everybody knows the implication of what they are doing and the meaning of what they are agreeing to. I think I'll stop there for today, and then tomorrow we'll probably be able to wrap up this discussion on agreements that we enter pursuant to a successful mediation. What is left for me to do today is to appreciate you again for coming and being part of this lecture, coming to this lecture, being part of this lecture. And I do hope you gain one or two things or skills that will help your work as a mediator going forward. As I said at the beginning, this lecture is guided by the book, How to Resolve a Conflict. And as I've said in previous lectures, it's available both as a soft copy and as a hard copy on the Amazon sites, on various Amazon sites. Thank you once again, and I'll see you tomorrow.